You'd think when a purchase of a rare good falls through, a buyer would be quick to litigate to collect his or her good. But when the buyer is an advantageous reseller like in Bander versus Grossman, we'll see that waiting can be intentional, but there are consequences. A wholesaler agreed to supply a car dealer named Robert Grossman with a rare convertible. In 1987, Neil Bander contracted with Grossman to purchase the convertible. Bander believed that the car was undervalued. He intended to use the car, then resell it once the price increased, as was his usual practice with vehicles. The parties agreed on a $40,000 price, and Bander gave Grossman a deposit. However, Grossman learned that the wholesaler misplaced the title. Several months went by, and Grossman assured Bander that he was continuing to attempt to fix the title issue. After at least 5 months of waiting for the title, Bander's attorney told Grossman that he considered the contract breached and that they'd commence litigation. At that time, the car had reached an estimated value of $60,000. Bander filed suit over a year later in the New York County Supreme Court, seeking specific performance due to the unique nature of the goods. However, by this time, Grossman had already sold the car to another person for $225,000. By the trial date, the value of the car had decreased to $80,000. At trial, the jury awarded Bander $20,000, the difference between the value of the car when Bander learned of the breach and the contract price. Bander challenged the verdict and argued that he should have been awarded specific performance in the form of a trust based on the value that Grossman sold the car for.